United States, red state of Florida, and its honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good afternoon and welcome to this session of the Florida Supreme Court. We want to thank the 4th District Court and the Chief Judge and all the staff here for facilitating our use of the courthouse today for these specially set oral arguments. The first case on our docket today is Detzner versus the League of Women Voters of Florida. Counsel?
Mr. Chief Justice, and may it please the Court, I'm Daniel Bell, Deputy Solicitor General, appearing on behalf of the Secretary in this matter. We're here today to discuss the ballot language corresponding to one of the revisions that the CRC has proposed for inclusion on the General Election Ballot in November. Before we begin, I'd like to address a quick terminology issue. Our briefs refer to Revision 3, and the other side's briefs use the number 8. The number 3 is the designation provided by the CRC, and the number 8 is the ballot position assigned by the Secretary. We have no objection to the use of the number 8, and I'll be referring to the revision throughout my argument. The revision at issue in this case would, if approved by the electorate, make 3 changes to the Florida Constitution concerning public education. The respondents challenge only the ballot language corresponding to one of those changes, specifically the revision's effect on the pre-existing constitutional duty of the district school boards to operate, supervise, and control public schools. I won't belabor the legal standard. I'll just state briefly that the only question before this court today is whether the ballot language at issue accurately and clearly discloses the chief purpose of the amendment, which this court has said is its legal effect and nothing more. And we would submit that it does. The affected constitutional provision, Article 9, Section 4, currently gives school boards the power to operate, control, and supervise all public schools. The revision would add a limiting clause to that phrase that would limit that grant of authority to just those schools established by the district school board.
And what do you say is the chief purpose of that, of which the voters are advised?
The chief purpose of that, Your Honor, is to extend to the state rather than to the school board a power to operate, supervise, and control the schools not established by the school board.
Is that reflected in the summary?
Yes, Your Honor, it is.
Okay.
Yes,
Is it actually reflected in the amendment itself? Does the amendment itself say that the state would now have control of, the state would operate, all those other terms that are in there, schools that are not established by school districts?
No, Your Honor, that's a very good question. The revision itself would be silent. It would leave the Constitution silent as to who shall operate, supervise, and control schools that are not supervised by the school board.
So what is the voter to think, and who would have control of any schools not operated, not established by the school district? So if a voter is reading that, who is the voter to think is going to operate some other kinds of schools?
I'm sorry, Justice Quince. Let me back up a step and just make sure that we're on the same page. So only the ballot language, the clarity of the ballot language is at issue here. The ballot language tells the voter that the revision, if approved, will permit the state to operate, supervise, and control these schools. And the revision itself has that legal effect.
We're not to look at the actual amendment itself to see if what is in the ballot reflects what is in the amendment?
So the revision itself, if I understand Your Honor's question, It's correct that the ballot language includes this phrase that does not appear in the revision, but that revision is not what is before the electorate.
That phrase doesn't, but is there any reference in the actual amendment itself that reflects that?
No, Your Honor, there's no direct language to that effect, but by leaving the Constitution silent as to who shall operate, supervise, and control the schools not established by the school board, like many statutes, the legislature would be able to operate in that gap, and that is precisely what the ballot language discloses to the voter.
Let me ask you this. This amendment, assuming it's passed on, is election the 7th or the 8th of November? One of those days, I believe. Okay, so
Get me on the spot there.
so the amendment is approved, okay? When does the legislative session start next year? It would be either January or March, one of those. And if I wanted to establish a school, what would I do before the legislature acts? I would be able to say I have a school and I don't have to go to the school board. Who would I go to?
I'm sorry, are we referring to it? Is Your Honor referring to it?
Talking about in the interim before there's anything done by the legislature.
I'm sorry, is Your Honor asking who currently establishes public schools? Is that the question?
Yes.
Okay. I'm happy to address that. As I read the statutes, so the Florida Constitution is silent as to who shall actually establish public schools. That question is left to the legislature, and the legislature has provided in section 1003.02 that the public schools within a given school district must be established by the school board. And
Must be what?
I'm sorry, it must be established by the school board for that district. And the phrase used in the statute is the public K through 12 schools, and that would include all of the variety of public K through 12 schools provided by statute.
See, my problem with this, and it was, I think, what the circuit court zeroed in on, is whether the ballot title and summary establishes the, I think it's called the true meaning of the amendment. And it is pretty clear from looking at the briefs that the true purpose was to take away responsibilities from the school boards and transfer it to either the legislature, the state, to a private commission. And I've looked at this. I keep on going back and forth between the title and the actual amendment, which is very, as you say, almost, so simple in what it says, to see how a voter would know that what we're really talking about are the charter schools, the supervision of charter schools would be transferred from school boards to some other entity not really known to anyone. So why is that not misleading as to the chief purpose of that part of the ballot summary is, and what's your answer to that?
I apologize. I'll have to answer Your Honor's question in a couple of parts. That's a fairly complex one that I think.
Well, it's really at the heart of what the circuit court found, and what the appellants say here is that it's fine if this is what the Constitutional Revision Commission wanted to do, was to take away power from the school boards and transfer it to the state. That is a valid decision, but the voters need to know that is what is in fact happening, so they know how to cast an intelligent vote.
Your Honor, I think that actually that effect is precisely what the ballot language communicates, that it is maintaining the school board's responsibility as to certain schools.
Well, first of all, it uses the word established, which is nowhere in anything before or before. What does that even mean, established?
So we think, Your Honor, that establish has a very plain dictionary meaning, which means to create or to institute. That term actually is used throughout the education code. And the section 1003.02, which I referenced earlier, actually uses the word establish and says that the district school boards will establish the schools within their district. So I think it's fair to understand that the voter would be aware of that statutory background. This court's precedents, in fact, presume that the voter will be aware of the relevant statutory background. That term actually does appear in the education code. And for example, charter schools have been, to date, established by the district school board.
And so charter schools right now are established by the school boards.
That's
right?
correct, Your Honor.
And so if this amendment passed, those charter schools that are presently in existence would still be operated, supervised, all those work regulated by the school boards. But then new charter schools would not.
That's actually not correct, Your Honor, because the revision itself would actually have no effect on any existing statute. And so in that respect, there is nothing that needs to be disclosed further to the voter, because all the revision would do is leave room in which the legislature may operate. The revision itself would not repeal any existing statute that provides
for. So the answer would be yes, that the school board, the school districts would still have the same supervisory power over those charter schools that are presently in existence.
That's absolutely correct, Your Honor. And
unless the legislature says otherwise.
Unless and until the legislature says otherwise. And I think...
But could they even do that if you've already said that this amendment would say that they have that supervisory power over those schools established by it? And presently, you just also said that the school board and the school district does, in fact, presently establish the charter schools, right?
I'm sorry, Your Honor. I'm not. It's entirely my fault, but I'm not sure I was able to follow your question.
So they don't establish the charter schools.
No, Your Honor. The school boards do currently establish the charter schools. The charter school is created when the school board signs a contract referred to as the charter with the school itself. And in the statute, the statute section 1003.02 actually says that this is the establishment of the school. So it is currently the case that these charter schools under the current statutes are established by the school board, and for that reason, even if the legislature were to, after the passage of the revision, change any existing statute as to who operates, supervises, and controls charter schools specifically, it wouldn't affect any, that legislation would not affect any charter school that has already been established.
Well, we really don't know that. I mean, that's the issue of whether it is ambiguous, whether it will create litigation in the future is something not before us. But one thing you said that they were only attacking, or the appellees were only attacking that one part. My concern is that in the title and then in the summary, before you even get to what is a fairly monumental shift in authority to public schools that are chartered and other types of schools, you get to things that are fairly non-controversial and well-known, term limits for school boards, and then the teaching of, I think this is the one, right, that has civic literacy. So is there any, you don't see that someone's reading this and they're going along, okay, term limits, great, duties, yeah, we want school boards to have duties, that this third really large part of what's happening as far as the administration of charter and other types of schools like that are going to be shifted. And as a voter, I would find that to be really hiding the ball, as we've used that term. And so why isn't that aspect, not that you can't bundle unrelated things, but the way this is placed is further reason it's misleading?
Well, Your Honor, the only question before this court today is whether the ballot language is clear and whether it's accurate. And we would submit that it is. Looking to the ballot language corresponding to each of the three aspects of the revision, that is that respective aspect of the revision is accurately described. And we would submit that that is the only question before the court. The argument that the respondents have made in their briefs, and the court below erred by accepting this argument, is that by bundling the otherwise defective language together with a couple of other proposals, the CRC was effectively hiding that defect. But that argument actually depends entirely on the defect itself, and for the reasons we've discussed and the reasons that are discussed in our briefs, we think that there is no defect, and that bundling argument is entirely coextensive with those arguments and therefore fails as well.
I'm not sure I still heard an answer to the question as to why the positioning doesn't create an ambiguity.
Well, Your Honor, I think the question of bundling and the question of clarity are separate inquiries.
You don't think you can ever be coextensive, the two?
Well, Your Honor, it's entirely possible that there may.
That's the question I think has been posed to you: is why the positioning here is not one of those in that category.
Well, Your Honor, the respondents have not offered any reason, and the court below found no reason why any of the ballot language corresponding to the other two aspects of the revision, the civic literacy and the term limits, would render the ballot language corresponding to the change to the school board power to operate, supervise, and control schools, why there was any interaction there that would cause that language to be misleading. The argument was simply that you've got multiple things put together. One of them is defective, and by having a couple others there, that'll hide the defect. But again, only if that defect is actually a defect is there a problem. And we would submit, Your Honor, respectfully, that there is not.
And you do agree that the standard is that the chief purpose must be set forth in the summary?
That's correct, Your Honor.
And would you tell me the words that demonstrate the chief purpose?
Certainly, Your Honor. The revision, if adopted, I'm quoting here, would permits the state to operate, control, and supervise public schools not established by the school board.
And what does not established by the school board mean?
Respectfully, Your Honor.
Do we know from looking at the ballot?
I don't think we necessarily know exactly how that phrase would apply at the meets and bounds. What I would say in response, Your Honor, is that is the same language used in the revision itself.
But here's the problem again, and when you say this chief purpose, is this a 75-word ballot summary?
I apologize.
Somewhere,
I haven't counted.
Okay.
It's probably close.
You're reading along. You're a voter. You're about to vote on several, 8, 10, whatever it is, constitutional amendments. You're reading along term limits like that, civic literacy like that, the duties of the school board, they got to operate. And then you don't get until the very last 1.5 lines to what you say is the chief purpose of this amendment. And it would be so easy to put it in there to not mislead the voter. That's that's what I'm concerned about, is why it was written like this, why it was bundled like this, and say, well, we only have 75 words. But if that's the chief purpose, it's at the very end of the 75-word limit, isn't it?
It is the last clause. That's absolutely correct,
But that's the
Your
chief purpose, is what the state is saying.
Well, no. Our position, Your Honor, is that there are 3 changes to the Florida Constitution here, all of which concern public education. And the debates in the CRC make clear that that is the reason why these were bundled in this way, because they're all on this topic. And respectfully, each of those 3 changes is a chief purpose that must be disclosed. And they're in a particular order. Regardless of which one comes last, something is going to come last, and the voter is going to get to that last. In this instance, this is just the way that it was assembled, and I don't think there's anything in the record to support that the CRC was trying to hide the ball.
Okay. Counsel, you are now well into your rebuttal time. I will nonetheless, if you want to stop now, I'll afford you 5 minutes for rebuttal.
Thank you very much, Your Honor.
Justice Kennedy, members of the court, my name is Ron Meyer. I'm here on behalf of the appellees. With me at council table is Lynn Hearn from my office and Scott McCoy from the Southern Poverty Law Center, which has joined us in bringing this action. There's nothing that is perhaps more well established in this area of the law than the fact that the ballot title and summary has to be viewed through the lens of the voter who's showing up at the voting booth to cast an informed ballot on a constitutional amendment. That ballot summary has to be written in clear and unambiguous language, and it has to be an explanatory statement of the chief purpose of the measure. When such wording selections render a ballot title and summary deceptive or misleading, the law requires that such proposal be removed from the ballot. That was this court's decision in the Slough case. There is no definition in the Constitution of Florida as to what is a public school established by the school board. There's just simply a new category that's being carved out of what has been the wall-to-wall authority conferred by Article 9, Section 4 of the Constitution, that local elected school boards shall control, operate, and supervise all schools in the state.
On that point, which I think is correct, I think you're absolutely correct, this is a new category, wouldn't the voter who is examining the summary understand that point? They would first understand from what's in the summary on this part of the proposal that school boards now have duty, and I think we would imply with that would be authority with respect to all public schools. That's in there, right?
We believe that's in there. The state hasn't taken that position in its brief. Today he said there's a statute that says they have that. I'm
talking about what's in the summary. I'm talking about what's in the summary. They would understand from the summary. I mean, because you look at it there, and it says that.
It says it maintains the school board's duties to public schools it establishes.
Well, no, I'm not talking about that. It says currently school boards have a constitutional duty to operate, supervise, and control and supervise all public schools. So correct. You've got this disclosure here that the school boards have this authority with respect to all public schools, and then that's followed by the statement that this amendment is going to create something new, and which will permit the state to operate, control, and supervise public schools not established by the school board. So it seems like to me a voter reading that is going to understand, a voter would have to understand, this is going to take away something from the school boards, which is what it would accomplish. Isn't that correct?
Well, here's the problem with that rationale. That's not what the amendment language does. The amendment language says the school board shall operate, control, and supervise all free public schools established by the district school board within the school district, period. It says nothing about permitting the state, the legislature, or any other entity to establish schools that are not established by the school board.
But the status quo is, which is as described here in the summary, is that they've got this universal authority with respect to all public schools.
School boards do.
School boards do, under the current state of the law. That's in the summary. And this amendment is changing that. It's limiting their authority, potentially, to schools that are established by the district school board. And it just seems like to me, I understand there are nuances in this. There are always nuances. There are always things that somebody might not understand, but I'm having a hard time understanding why this basic point here, that something is being, some authority with respect to public schools that's currently exercised by the school boards, is being lost. Now, the legislature might not take it away from them. I guess they could still give them, do something under this amendment that would not truncate it, but it's opening up something there for the state that is not currently available. Isn't that correct?
It's clearly opening something up, but what is it opening up? First of all, it's opening up something for a category of schools that's not defined anywhere.
So is it your...
But that's a problem. It seems to me, when you make that point, that indicates a problem you have not with the summary, but with the proposal itself. And I understand you got a problem with the proposal. I accept that, and I understand the policy reasons that people would have a problem with the proposal, and that can be fought out. But that's not a reason to keep the people of Florida from having an opportunity to vote on this. The question is whether they're going to be somehow, basically, the question is whether they're going to be somehow fooled about what they're voting on. And I'm still struggling to understand why they aren't going to get the main point here, that the school boards are going to lose some authority, and then this will open it up to the state to have greater authority than that will be taken away from the school board.
And I submit to you the people are going to be fooled by this ballot summary language. The people are going to be told improperly that this amendment permits the state to operate, control, and supervise public schools.
And what's inaccurate about that? What is inaccurate about that?
Because there's nothing in the amendment that does that, first. Secondly, what's the state? If you read the summary, it starts out saying that requires the legislature to provide for the promotion of civic literacy in public schools, but then it jumps down and says permits the state to operate, control, and supervise. Now, the appellant wants to make the state and the legislature the same thing, but that's not the same thing, Your Honor.
Well, you understand that under our you say any amendment that affects the policy-making branch of government has to explain the basic structure of our Constitution in the 75 words so that the people will understand that if there's a policy decision that has to be made, it's the legislature that's going to do that?
No, Your Honor. What I'm saying is when the drafters of the summary use the term, the legislature shall do something here with respect to civic literacy, but the state shall operate, control, and supervise public schools, what is the voter who is reading that to conclude? It must be something different than the legislature. It may be the State Board of Education. It may be the State Department.
And it well may be, because the legislature could give it to the State Board of Education.
But where does it say the legislature gets to do that, Your Honor?
Well, I think that, what is that, Article 2 of the Constitution?
You really think that people wouldn't understand that when something refers to the state being able to do something, that wouldn't clue them into the fact that the legislature is
Your Honor, I don't think
have authority there?
I don't think the people should be asked to guess at what's meant
when
they use legislature in one line
don't we
and
have to
state in
assume,
another line.
Speaking of civic literacy, don't we have to assume minimal level of civic literacy about the structure of government and the responsibility of the legislature? So to have this process make any sense at all. Otherwise, you're going to be kind of going, there's no way you could have a summary that would be adequate to explain. You'd need a textbook to explain all the things that you need to explain. That so I'm just struggling to this idea that when it refers to the state, that people aren't going to understand that would open up an opportunity for the legislature to act.
Your Honor, I can only go back to the cases that this court has decided and looking at this language to determine whether the language in clear and unambiguous terms informs the voter.
Do we have a case that, and we may, do we have a case that says that when the state is identified as an actor, people would not understand that would carry with it authority of the legislature?
I don't know of a case that says that, no, Your Honor.
We don't have any case like that.
I don't know of a case like that.
Well, you think you would have found it if we had it?
But I'm suggesting to you, I read words.
You're a good lawyer. I know you're a good lawyer. I'm quite confident you would have found it if we have it.
Let me going just on the ballot summary itself, and it does appear that there is a disconnect between the ballot summary and the actual amendment, which is, as to this, is only 5 words. What is it, clear and unambiguously, and maybe Mr. Bell told us, that what are the public schools that the school board establishes currently? What are they? Are they what we consider the regular public schools? I mean, the free.
Your Honor, that's part of the problem.
Well,
There's
but
no
let's get to that.
guidance here as
well,
to
what is it? I'm asking you your best. I mean, are they? what are they? And then, therefore, what are the public schools not established by the school board?
Well, I can
What is
refer
that?
back to the Duval decision cited in our brief. That was when the legislature created a separate organization to charter public schools of charter school nature outside the sweep of
See,
control
I think
of
that's
school
the
boards.
best, to me, what makes it the most confusing, because if you're reading this, all they had to say was something such as charter schools, that I think most
People
voters
understand
would
it.
know, okay, now we're talking about the public schools that most people send their children to, but now we're talking, and then the state will then have control over those non-traditional schools. And as the amicus from the charter school group says, that, and as some of the others, they don't like the school board's monopoly on other kinds of innovative schools. So, but is that, again, if we're not looking at what everyone's saying and reading that, would you, as a person who represents teachers, schools, be able to tell us, under the current state of the law, what are the ones that the school board establishes and what are the ones that the school board doesn't establish?
Your Honor, we believe that the school board establishes all K-12
So that's what, to
schools.
me, makes
Yes.
it misleading and confusing, not
and now
this
we're going
other
to take a
state.
subset of those away.
But that's why when you say something, oh, it's the state, they don't know it's the state, it's the legislature, that seems to be starting to be nitpicking. But this, I've read over and over, I don't know what they're talking about.
It's a
except
title
that-
change. It's huge because now all of them are operated, controlled, supervised, authorized by local elected school boards.
So then this would be accurate in saying currently district school boards have a constitutional duty to operate, control, and supervise all public schools.
That is accurate.
That is completely accurate. And then the amendment maintains the school board's duties to public schools it establishes. The
We don't
amendment
know what
does that,
those
right?
are.
But that's a problem with the constitutional provision,
But
right?
shouldn't we have some idea before we're going to carve out a subset of all of these public schools and we're going to permit the state, whatever the state is, to suddenly take over them?
But
shouldn't we have an idea as a voter to know what we're talking about?
How can you know what the legislature is going to do? All that you can explain in a summary is the authority that's given, but how can you know what the legislature is
Your
going to do
Honor,
in
all
advance?
you have to explain in the summary is to the voter that you're giving up what you now have. What you now have is elected school boards that are supervising, operating, controlling all of the public schools, and you're going to give up some of them. We're not going to tell you which ones.
It says the amendment maintains the school board's duty to public schools it establishes, but permits the state, not the local school board, the state, to operate those that it doesn't.
Is it schools that it establishes after the amendment? We don't know. It's ambiguous. Your Honor, there are so many
But that's a problem.
ambiguities in
Isn't that a problem? To the extent it's a problem, isn't that a problem with the underlying constitutional language?
Well, but when there's an ambiguity in the underlying constitutional language, it becomes all the more important for the summary and ballot title to explain the chief purpose. That was the holding
But the logic of that, if your argument is that there's an ambiguity that will be resolved in future litigation as to the constitutional language, how can a summary do anything but give you that language? Because otherwise you would have to predict that this could in the future play out this way, it could play out this way, it could play out this way. I mean,
Your Honor, all we're saying is that when the voter presents and reads this ballot summary, they're not being clued in to the fact that what they have now is being substantially and in a major way eroded in a manner and to an entity that's not defined, that's not drawn any kind of normalcy in the sense that the language used, established by district school boards, isn't a word of art, isn't something that's established in the Constitution. You're changing the Constitution substantially, taking away control, and, you know, quite frankly, for the past year, the CRC has been talking about this as exclusively to overcome the Duval decision and to empower charter schools. Why didn't they just say that? Why did they hide the fact? Why did they come in with this cutesy language and ballot summary that doesn't disclose what they're doing.
And the cutesy language you're talking about is the language in the Constitution, those established by the school board? Okay.
Yes. Why did they use language that has a meaning constitutionally?
Mr. Meyer, do we have any authority that addresses whether a mere regurgitation of words from the amendment itself satisfies the clear ballot summary?
Yes, Your Honor, there is some authority.
What does that tell us?
Well, what it says is the summary has to do more than regurgitate what the ballot itself says. It has to explain. It has to develop what the chief purpose and effect of this measure is. Because the voter can't go to the actual language and get the answer. In a lot of amendments, we get a summary that's a little vague or misleading. You can go to the language and find out what it means. Here, you can't do that. And so, yes, Your Honor, there are cases cited in our memorandum that point you to the fact that where there is a deficiency or an ambiguity in the underlying language, it's all more important that the title and ballot summary do it. And this ballot and title summary fails that entirely.
But isn't that about explaining the legal background that exists? Our case law on that focuses on explaining the kind of the legal context that's going to be changed. But it seems like this amendment does, the summary actually does it. And the more I listen to your argument, the more it becomes apparent to me that your real problem is not with the ballot summary, but with the proposal. And I understand, again, having a problem with that. That's fair, and that can be fought out. But isn't it true that this court has just precedent after precedent in this area where we say we don't look at the merits of the proposal. We're looking at the ballot summary to decide whether it is sufficient, or more accurately, whether it is clearly and conclusively defective. And your whole argument really hinges on your problems with ambiguities or uncertainties in the text of the actual amendment itself. Isn't that true?
No, it's not true. Our problem, first of all, has nothing to do with the policy considerations. That's up for debate. Our problem is that the voter presenting at the voting booth is not being told what's happening here. It's not being given an explanatory purpose. And further, the way they've combined these three issues and omitted any meaningful discussion from the ballot title was done in a way that further misleads and further hides the ball when you look at the ballot summary and title here. The fact that it's titled School Board Term Limits and Duties Public Schools and goes to great length to describe term limits and the need to teach civic education and hardly anything to do with what is the major change in this amendment. We suggest to you that combining of these three issues, we're not urging a rule of law that you can't log roll. We think it's bad policy. The fine court described why it shouldn't be done, but unlike a citizen's initiative, it's not single subject. But the point is when you start combining disparate ideas like this in a way to basically camouflage and hide, you're further misrepresenting the true purpose and effect of this amendment. And that's what this ballot summary and title do.
I'm totally unclear as to how anything is camouflaged here by the combining of these proposals. You've got these different discrete statements about the different proposals. How does that camouflage anything? Now, it's one thing if you think it's not adequate in what it says about one of the proposals. We've discussed that some.
Right.
And there may be different opinions about that, okay? But this idea that something's being camouflaged because for the three things, because the three things are in there, I find that to be incoherent. I do not follow it. Help me understand.
When you name the amendment School Board Term Limits and Duties Public Schools, that's what the common referred to title of the amendment is supposed to be. Where do you get any clue that it's, and by the way, take away the exclusive authority of local school boards that presently exists in the Constitution? Simply not there.
I mean, all the case law says you read them together, right?
Correct.
Okay, so if I understand your argument is to this point, if it was switched around and said public schools and school board term limits and duties, and then the second sentence was the first sentence, so it started with currently school boards, then that would not be misleading.
I think you would have to do more than rearrange the ballot summary in this case, Your Honor.
I mean, I understand you have another argument with respect to the language. We spent time talking about this, but I mean, is it right now you're talking about just the order, that you have to get to the second sentence in order to see that they're talking about a school board's authority to control and operate all public schools?
Not just the order, Your Honor, but the fact that...
What other than the order?
I'm trying to get your eye off the donut here. Something that is easily understood and easily described and is, in fact, well described in the summary, dealing with term limits, something that is easily understood in common language that's easily understood by the voter, teaching civic education, doesn't require any special leap. Packaging it that way, calling it term limits amendment, and in fact burying the proposal that makes such a seismic shift in the authority of
Before you sit down, I have one other question I want to ask you, and this is about, I'm still troubled about this schools that are school boards duty to public schools it establishes. Are there presently public schools that are not established by the school board?
I don't know of any in the K-12 system that you could say, Article 9 uses the word established for establishing institutions of higher learning, but in terms of K-12, there's nothing constitutionally that says there are school boards not established by the local school board.
So schools like virtual schools and those kinds of schools are still established by
local
the
school
boards or school districts, whichever term you want to use. And so I'm trying to figure out if a voter would understand from this summary that at present it says currently districts that have a constitutional duty to operate, control, and supervise all public schools. But if all public schools are also established by the school district, I'm struggling with what even the second part means. Right. That at some future point, those schools will no longer be established by the school board?
And I think the point here is that nobody knows what that means, Your Honor, and that shouldn't be the basis for a voter to make an informed decision on a constitutional amendment.
We thank you for your argument.
Thank you, Mr. Chief Justice.
Mr. Chief Justice, I'd like to briefly address what I believe to be a chief concern raised by several members of the court, and that is that voters will come to the ballot and simply not know what the phrase established by the school board means. And Justice Lewis, you asked whether we have precedent dealing with the regurgitation of a term in the amendment in the ballot language. This court absolutely does, and in particular, I would submit that this case is a very straightforward application of the Marriage Protection Amendment case. There, both the ballot language and the amendment used the phrase substantial equivalent thereof in relation to the word marriage. And the court held that use of that same phrase in the ballot language was acceptable and would go for a vote because it was the same language as the amendment and because it was not an undefined legal term. And the court acknowledged there that while there would be, of course, questions down the road as to how exactly that phrase might apply, what are the metes and bounds of a substantial equivalent of a marriage, that those questions were not before the court because the only question before the court was the accuracy of the representation of the legal effect of the revision. And by using the same term, the ballot language did that. And we would submit that that is exactly the case here. Not established by the school board is not undefined legal terminology. And I think we get some guidance.
What is it, okay, going back to what we were talking about, it's the difference is they have to maintain their duties to public schools it establishes, but not to ones they don't establish. So what are the schools currently that they don't establish?
Your Honor, I'm not aware of any, and opposing
So
counsel.
that's, okay, so maybe you answered this the last time around. I'm still trying to understand. So what is it that voters would understand were being affected by the, penultimate sentence in here, which is what it maintains and then what the school boards are giving up? How would a voter know what it is?
Your Honor, like the revision itself, the phrase used in the ballot language is all public schools. All public schools has no temporal limitation. I would submit that the revision here is entirely, as far as I understand it, forward-looking, as we've established on both sides.
So would it mean that even if it's not a traditional public school, if the state comes in and says we're going to establish more magnet schools, not charter schools, we're just going to operate more other types of public schools, IB schools, School of the Arts, can they come into a community and establish those schools?
Pursuant to this revision, Your Honor, the legislature would be able to do that so long as it has provided for the establishment of those schools in some way other than by a school board. That's exactly correct.
So if they wanted to fund lots of good public school education, they could come in and into a school district and do so.
That's exactly correct, Your Honor. And the ballot language fairly discloses that to the electorate by informing them that this would affect all public schools.
So I'm clear, as of today, the way things stand today, every voter has every right to believe that the school board establishes all public schools in our state.
Your Honor, I think this court's precedents do presume awareness of the statutory background, and that is the state of the law.
So your answer is yes?
Yes.
Right. So why would it be not clear if the proposed amendment would say, from this day on, the legislature will be permitted to establish public schools in Florida? Then people would know that someone other than the public schools, the school boards, established them. That would have made it easier, wouldn't it? From this day on, the Florida legislature will be permitted to establish schools in Florida, public funds.
Your Honor,
I would have cleared all this up.
Your Honor, so I would submit that the ballot language as it is written is accurate, and that this court's precedents require that we consider only the ballot language that is actually put together by the CRC, and that ultimately whether it could have been written a different way is ultimately not.
If a task here, if your objective here is to inform the voters as to what is going to happen, why all the wordsmithing? Just come out and say it. The legislature will be permitted to establish schools in the state of Florida. Pass a statute. From now on, there will be charter schools, period. That's what it says.
Your Honor,
that's what you mean.
Your Honor, the Constitution currently does not address who shall establish public schools, and the revision would not affect who shall establish public schools. It's both the Constitution, the revision, and the ballot language are silent on.
Okay, so I'm the voter. Today, it is my view that the school board establishes all public schools in this state. Now, someone else gets to establish public schools in this state at public funding. Who is that? How do I know who I'm allowing to establish schools in my state?
I think the answer, Your Honor, is that the revision is silent as to who shall establish the subset of schools, those not established by the school board, and it leaves that to the legislature by being silent on that point, and that the revision discloses precisely that, saying that it permits the state to act in this area. And the vote, this court's precedents presume that the voter will bring a certain degree of common sense and common understanding to the ballot box. And in particular, I think the voter should be presumed to be aware that the state is an entity that acts only through its agents, and therefore that the legislature may delegate responsibility over this category of schools to a variety of entities and officers.
We thank you. Your time has now expired. We thank you both for your arguments.
Thank you very much.
We will now move to the second case on today's docket. Consolidated cases of Department of State versus Hollander and Department of